All right, this is going to be a breakdown video taken from the Senate Judiciary Committee's investigation into the U.S. Army's covert program called Able Danger. The Defense Intelligence Agency, led by Peter Shoemaker and Hugh Shelton, created this program, which was to allow for the Army and the Land Information Warfare's Activities Division, which did the technical work in collecting data, to use open source and closed source methods of obtaining data about terrorist operatives inside the United States. Now, this was a 2-hour long committee, which I only edited out the part in which we're going to see today of the Pentagon official named William Dugan, who's in charge of I believe it was he's the Assistant Defense Secretary for Intelligence Oversight. Now, a little bit of background to this. This comes at the heels of a senator named Kurt Weldon, a Republican out of Pennsylvania, who was brought to the attention of an anonymous phone call made by an official affiliated with the Able Danger program, where he told them that he had he was given an interview with the 9/11 Commission Director Phillip Zelikow at Bagram Air Force Base in Afghanistan in 2002 about the program itself. But the 9/11 Commission report failed to even mention the Able Danger program once. And so he actually, the anonymous phone call, who was interviewed by this person, reached out to Kurt Weldon. Kurt Weldon met him, and it turned out to be Anthony Shaffer of the U.S. Army, who was involved with the Able Danger program. I have been very grateful to have interviewed Anthony Shaffer and Eric Kleinsmith of the Land Information Warfare's Activities Division regarding their experiences with the program, what this program had accomplished. Shaffer is an important whistleblower, as well as Eric Kleinsmith, and it is indeed an oft-forgotten piece of history in which Shaffer and Kleinsmith and others that were involved in the program uncovered on a massive amounts of data about terrorist operatives inside the United States, in which they identified the future alleged ringleader of 9/11, Mohammed Atta, who was inside the United States. The Pentagon ordered Kleinsmith to erase all the data that was collected because they couldn't, according to the Pentagon, they weren't allowed to collect data on U.S. citizens. So they considered Mohammed Atta, Marwan al-Shehhi, and Ziad Jarrah U.S. citizens. Well, this turned out not to be the case. They were foreign nationals visiting the United States on expired tourist visas. And so because of that, because they were visiting the United States, they were not considered U.S. citizens. So why was the data ordered to be destroyed? That's the question. Let's see what William Dugan has to say. Heading the Senate Judiciary Committee is Chairman Arlen Specter.
We turn now to Mr. William Dugan, Acting Assistant Secretary of Defense Intelligence Oversight. Mr. Dugan is a retired Air Force colonel, had served as a Minuteman Missile Combat Crew Commander, a Bachelor of Arts degree from the University of Florida, and a law degree from the University of Kansas, also a graduate of the Army War College. The floor is yours, Mr. Dugan.
Thank you, Mr. Chairman. Good morning, Senator Sessions and members of the committee. It's my privilege to appear before you today. I'm Bill Dugan. I'm the Acting Assistant to the Secretary of Defense for Intelligence Oversight, and I'm here to discuss the Intelligence Oversight Program in the Department of Defense and also to talk about an information sharing. I am responsible to the Secretary and the Deputy Secretary for the DoD's Intelligence Oversight Program. And the purpose of the Intelligence Oversight Program is to enable DoD intelligence components to carry out their authorized functions, while at the same time ensuring that their activities that affect U.S. persons, United States persons, are carried out in a manner that protects their constitutional rights and privacy. Now, I've used the term United States persons, and I would like to define it because it is an important term. It's a broad term. It refers to more than just United States citizens. The term also includes permanent resident aliens, corporations incorporated in the United States unless directed or controlled by foreign governments, and associations composed of permanent resident aliens and United States citizens. So you can see it's broader than just U.S. citizens.
Sure. Now let me stop you there. Mohammed Atta, Maulana Shehi, Ziad Jarrah were not permanent resident aliens. They were here on temporary visas. So they would not apply to be well, they wouldn't be authorized to be labeled as U.S. citizens, not by Dugan or the Pentagon's definitions.
We operate under Executive Order 12333, entitled United States Intelligence Activities, which was issued by President Reagan in December 1981. The DoD implementing regulation is DoD 5240.1-R, entitled Procedures Governing the Activities of DoD Intelligence Components that Affect United States Persons. This DoD regulation was approved by the Attorney General and was issued in December 1982. So these are the Attorney General approved guidelines for the DoD intelligence community regarding activities that affect United States persons. And they have been in place for more than 20 years. The Office of the Assistant...
A little bit of background, too, about the program, which was created in 1996. It wasn't in opposition to the CIA's Bin Laden issue station. When Able Danger program was first initiated, it wasn't even known to many in the Pentagon either. So Shelton and Shoemaker, they basically kept this program under wraps and wanted very few people to be involved. I think altogether it was about 6 people involved with the Able Danger program. Dr. Eileen Presser, Eric Kleinsmith, Anthony Shaffer, I want to say Mike Smith, I think I might get his name wrong. And 2 others, I forget their names. I'm sorry. There's so many names I got to remember, and I'm getting older. Anyway, there weren't many, but what they did was they allowed other programs to be involved, like Orion Scientific, which created the charts of the data, the names of the people that were involved with certain terrorist groups, and it was a huge chart. They made a whole bunch of charts, and those charts also, very few of them survived. And later on, after 9/11, Dr. Eileen Presser had met with Anthony Shaffer and showed him on the chart Mohammed Atta's name. And they certainly did warn U.S. officials that these people were inside the United States and they were involved with terrorism. And, you know, Shaffer and Kleinsmith and them, you know, they came under fire for this. And, you know, you have to ask yourself why.
The Secretary of Defense was established in 1976 to implement the original executive order, which was one issued by President Ford. And that was in response to the investigations, including those done by this committee, that revealed the misuse of intelligence assets, both DOD and non-DOD, to collect information on civil rights protests.
By the way, just to add, when Shaffer had met with CIA officials at Alex Station regarding the program, CIA basically said that they considered Able Danger a threat to their program, would not assist with them in regards to data sharing. It just goes to show you that not everybody, even in the United States, is playing on the same side, which you would think would be the case. They work for us, the people. These are our defense, allegedly. They're supposed to be defending the security of the American people. And here they are acting like petulant children, not sharing information. I blame the CIA for that and a lot more.
Protesters, anti-Vietnam War demonstrators, community and religious leaders, etc. The lack of... Also, not to keep, I'm sorry to keep pausing, the person over to his left is Kurt Weldon, who was the senator that talked with Anthony Shaffer on the phone. Clear rules, mission creep, and the lack of meaningful over... Oh, by the way, when Weldon's staffer, I think it was this gentleman over here to his right, when they called the 9/11 Commission, they got in touch with a staffer named Chris Kojum, and the staffer of Weldon, I forgot his name, basically said, well, you know, have you heard the name Anthony Shaffer? And Chris Kojum said, yes.
He goes, well, why didn't you use his information, which, he gave to Phillip Zelikow? And according to Chris Kojum, he said, it's not part of the story that the 9/11 Commission wanted to tell. And when Kurt Weldon heard that, he was basically in shock. I think you would be too.
Oversight caused an abuse of the constitutional rights of United States persons by defense intelligence and counterintelligence personnel. The result, President Ford's first executive order and the one we operate under currently by President Reagan, 1981. I would like to describe how the process works regarding the collection of United States person information by DoD intelligence components. First, no one in DoD intelligence has a mission to collect information on United States persons. What we have are missions such as foreign intelligence, counterintelligence, counterterrorism, signals intelligence, and the like.
Boy, does that all change after 9/11, right? I mean, right here, basically, he's talking about guidelines that existed before 9/11. After 9/11, that wasn't the case. I mean, everybody spies on Americans now, even the Pentagon.
In the course of performing our mission, we run across or find information that identifies United States persons. That is when the rules in the DoD regulation that I mentioned, 5240.1-R, kick in, the Attorney General approved guidelines. If the information is necessary to the conduct of the mission, as I just described, for example, counterterrorism, and if it falls within one of the 13 categories prescribed by the executive order and the DoD regulation, then the intelligence component can collect it. The 13 categories, I won't list them all, they are in my prepared remarks, but the ones most likely to be used in the war on terrorism are information obtained with consent, publicly available information, foreign intelligence, counterintelligence, and threats to safety from international terrorist organizations. If the intelligence component is unsure if the information they have obtained is proper for them to keep regarding U.S. persons, the Intelligence Oversight rules allow them to temporarily retain the information for up to 90 days, solely to determine whether it may be permanently retained. And thus we have intelligence components who have properly collected U.S. person information in their holdings.
That's right. And so when U.S. Army lawyers, SOCOM lawyers, Southern Command lawyers, warned Eric Kleinsmith about keeping the data past the 90-day mark, they advised him to destroy the data. And I think it was, according to Shaffer and Kleinsmith, it was like 3.5 terabytes of data. At that time, it's enormous amounts of data. That's a lot. Back in 1999, I think that's when they made the charts and got the data publicized on the charts. And, they didn't have to destroy that data because, as you'll see at the end of this, and I've seen this testimony before, Dugan actually tells the truth at the end, and I'm not going to blow it. So
finally, if an intelligence component is in receipt of information that pertains to the function of other DoD components or agencies outside DoD, such as the FBI, the intelligence component can transmit or deliver the information to them for their independent determination whether it can be collected, retained, or disseminated in accordance with their governing policy.
And according to SOCOM lawyers, they couldn't even share the information with a domestic agency, the FBI, because according to Eric Kleinsmith, in my interview with him on the Darkened Hour, and as well as Shaffer, they both said that they couldn't share the information even with the FBI because the FBI can't collect information on U.S. citizens. But these guys weren't U.S. citizens. And it just seems like there's a lot of bureaucrats and a lot of bureaucracy here and a lot of legal walls. These are called the walls, where they can't legally share information if some agency like the Pentagon says, well, these people are inside the United States, they have visas, we would classify them as U.S. citizens. But they weren't, according to the law. They're on temporary visas, which would mean that they're foreign nationals who are here temporarily. So they didn't apply for, say, so I forgot the name of the form where they file vocational form regarding either a student visa or a tourist visa or a permanent residency visa file, but they weren't filing for that, obviously. So they were here on a tourist visa. And so their visas, actually, the applications were approved in 1999, I want to say, 1998, 99. I think Atta came inside the country in 99, I want to say. Him and Marwan. First it was Marwan al-Shehhi, then Atta, and then Jara, or then Jara, then Atta, in that order.
Thank you.
Thank you, Mr. Dugan. Mr. Dugan, you were present during the entire hearing today.
Yes, I was.
I didn't hear you object to any classified information being presented.
By the way, for those who are not familiar with Arlen Specter, he's most infamously known as the person who created the magic bullet theory for the JFK assassination.
Sir, I listened to your reading of the statement from your legal counsel regarding my response.
For those who don't know, I'm actually drinking, not beer, I don't drink, drinking Celsius. I don't know if you could see it because Celsius. I don't drink energy drinks, but this energy drink is actually really good. But this one is a sparkling grape rush and has a very, almost like a very bitter taste to it. But as soon as you get it down, it really works. I was really lethargic today, more so than most. But I wanted to drink this a little bit to, prepare for this video. And it is an ass. I really got to, and I hate to like, be a commercial ad or something, but yeah, Celsius, very good. Outstanding, really. And I don't drink many energy drinks. I don't drink Red Bull, Monster, that's garbage. But Celsius is very good.
Responsibility to object if there was classified information revealed. My knowledge of Able Danger is very limited. The information.
Yeah, he's turning around saying, yeah, of course it is. But then again, I mean, can you blame Dugan? Like, this was a very covert operation, but you would think that the Pentagon brass would actually, brief William Dugan about what the program is about, because that's what the committee's about. I mean, God sakes, they just sent this guy out there. I mean, you would think like people like Rumsfeld or the Joint Chiefs, Richard Myers, somebody, the top officials would come and testify, but no, they send this poor guy out there.
Information that I heard discussed by the previous two panels, based on my limited knowledge of Able Danger, did not cause me to rise and say that I thought classified information was being revealed. Had I believed so, I would have done so.
Okay, so you didn't hear any classified information?
No, I didn't hear what I believed to be classified
information. And you can see Weldon and his staffer over here. I forget his name. He's great. And they're just like, looking at each other like, this guy's a joke. I mean, what are they, poor, this poor guy, he's already drinking the water. I mean, that's the Kool-Aid, I guess. But here you have, like, the whole Senate Judiciary Committee's investigation is into this covert program and about the silencing of Anthony Shaffer, because when Anthony Shaffer gave testimony, gave an interview to Phillip Zelikow, the Pentagon heard about it and said, all right, we got to, take away security clearance because we don't want this guy actually talking about the program. Why? And that's what Weldon, I have that uploaded on my channel when he went to the House floor and started screaming about how they, besmirched Schaefer's name and called him, they labeled him as a thief, stealing pens and having an affair. And Wolf Blitzer and CNN announced on CNN saying that Schaefer's fooling around behind his wife's back. I mean, it's disgusting what they did to Schaefer. I mean, really maligned him. And it was, disgusting. And Schaefer's a true whistleblower. He really suffered and paid a price. And, he co-authored a great book called Operation Dark Card. And I would You know what? I'm going to link it at the bottom of the description. Fantastic book. And the first 5,000 copies the Pentagon brought, and they burned it. First 5,000 copies, they went and burned it. The book is redacted, of course, because it does have classified information that the FBI has to approve to be released, and the stuff that they don't want released, they redact.
Well, we're not looking for anybody else's belief. Is there anybody else present from the Department of Defense here today?
I have some folks from the OSD Legislative Affairs, but I don't believe they're in a position.
But it was your job to object if you heard something you thought was classified.
Yes, sir, that's correct.
Is there anything in posse comitatus which would have prevented the Department of Defense from telling the FBI about an al-Qaeda cell and Mohammed Atta?
No, sir, I don't think so. I don't think this is a posse comitatus issue. I think this is an intelligence oversight, executive order 12333 compliance issue. The Army regulation that the previous speaker referred to, Army Reg 381-10, is an implementation.
A little bit. For those who don't know, I'm going to look. I'm actually going to look up the Posse Comitatus Act. Is a U.S. federal law signed on June 18th, 1878, by President Hayes, which limits the powers of the federal government in the use of federal military personnel to enforce domestic policies within the United States. That's what the Posse Comitatus Act is.
DOD regulation, which is an implementation of the executive order. And that is what they followed. Posse Comitatus, I don't think, bears on this.
Was there any basis under Posse Comitatus for the deletion of materials as testified by Mr. Kleinsmith, or the destruction of other records relating to Mohammed Atta and the charts?
I don't think so under Posse Comitatus.
Any basis for the destruction of those records or deletion on any ground?
Well, perhaps under the intelligence oversight rules and the 90-day retention determination period that I spoke of. That is under the DOD guidance, the Attorney General approved guidelines. If information identifies a U.S. person, the intelligence component concerned has 90 days to determine if they have a reasonable belief that it can be related to one of the 13 categories in Procedure 2 of the DOD directive. The Army directive is the same.
The rather extensive record for this committee today, albeit by hearsay, to some substantial extent, Congressman Weld's testimony and the other testimony has established the existence of intelligence information in the hands of the Department of Defense, including the identity of Mohammed Atta. That evidence having been presented, and if factually ascertainable, did the Department of Defense make a mistake in not telling the FBI about that prior to 9/11?
Not having reviewed the evidence that...
Well, you were here today and you heard all the testimony.
Yes, sir, I was.
You heard a lot of testimony that there was a cell uncovered on al-Qaeda, and that Mohammed Atta was identified, the Mohammed Atta who later turned out to be a ringleader.
Later on, in 2000, this is actually in 2005, September 21st, 2005, what this actual committee is dated from. Later on, after this committee, it later came, I think, I forgot the name of the congressional committee that later came out and said that, oh, the Able Danger Program did not positively identify Mohammed Atta. Well, that's in contrast to the evidence. It's already been known before that in 1999, when Dr. Eileen Presser met with Anthony Shaffer, showed him the chart produced by Orion Scientific Corporation showing Mohammed Atta on the chart. So they certainly did. And Shaffer testified to that fact. So did Kleinsmith. So did Mark Zaid, their lawyer. Okay? They were all testified here, but Shaffer can't testify. And this is the reason why Weldon's there to speak on his behalf. Now, Shaffer's there too. You can't see it in this camera view, but he's also there. But he can't testify because he's actually suspended by the Pentagon, and they took away his security clearance. So he's basically in limbo. Instead of just terminating his contract so he can go and talk about it to the public. And that's what they did to this guy. It's screwy what they did to him. But I mean, boy, I gotta give Spector here a lot of credit because he's holding Dugan's feet to the fire.
Now, I don't know whether it's true or not because we haven't had the firsthand testimony, but we have to accept what we can get. That is for a first hearing. We may have some more hearings.
Certainly.
But they didn't.
The Secretary of Defense is coming in to brief the Senate this afternoon at 4 o'clock. He may have some extra time. He may be able to lend some substance to what we've heard here today. But all we can do is accept the testimony we've heard. Now, accepting that testimony, if the Department of Defense knew about an al-Qaeda cell and about Mohammed Atta, the ringleader, wasn't it a mistake not to turn that over to the FBI?
If the INSCOM folks, following the regulation and their intelligence oversight rules, found that the information was properly collected and collectible, then it is under the Attorney General approved guidelines. They can retain it and disseminate it. And the dissemination under Procedure 4 of the regulation would be lawful to the FBI.
Should it have been
That's
disclosed?
wait a minute here. Wait a minute. That's in contrast to what the lawyers from the U.S. Department of the Army told Shaffer and Kleinsmith, that they couldn't share this information with the FBI because it concerned U.S. citizens. That was the whole. The whole argument is regarding this information shouldn't have been destroyed because it was concerning U.S. citizens, for which Mohammed Atta, Mohammed al-Shayzi al-Jarrah are not. The Pentagon stated that they were. The Department of Army lawyers stated that they couldn't share this information with anybody because it concerned U.S. citizens. But they legally weren't.
That's my question. Your last answer was circuitous and not to the point. Should it have been disclosed if it might have prevented 9/11?
If it was properly
Sure.
collected, yes.
Well, was it properly collected?
I don't know, sir.
Well, you say there's nothing that you heard about which puts it at variance with the Posse Comitatus Act.
Correct, but I haven't.
Wait. Let me stop right there. If this information was acted on, yes, it would prevent the 9/11. Getting the FBI involved with the monitoring and maybe even arresting, detaining Mohammed Atta al-Shayzi on visa violations, maybe. But if they were at least monitoring them right from the start, they may have not participated in 9/11 at all. And that if this sounds familiar, that's exactly what happened out west with Khalid al-Mihdhar Nawaf al-Hazmi regarding the CIA and the NSA withholding information from the FBI regarding these two men inside the country. How is nobody talking about this in a truth movement? That's because they don't believe in hijackers.
Heard testimony, whether and from the Army, and I understand they're not here and the reasons for that, but as to what they collected, how they collected it, and why they determined it was not properly collectible, and why it then could not be retained and then disseminated.
Do you know why the decision was made not to retain it?
I assume, based on the previous testimony of the previous panel, and from what he said, was that the 90-day period had run. And since the 90-day period had run, they had not made a collectability determination that if it fit into one of the 13 categories, that it was excluded.
Since you're the only representative from the Department of Defense here, we can only ask you to respond to the committee and to make a determination as to whether, number one, the Department of Defense had information about an al-Qaeda cell and Mohammed Atta, the ringleader. That's question number one. Did they have that information? If so, was there any reason under Posse Comitatus why they could not disclose it to the FBI or others intelligence agencies? And question number three, was it a mistake not to make that information available to prevent
That's a good question.
9/11, or perhaps contribute to the prevention of 9/11?
Mr. Chairman, with respect to your first question, did we have information that identified Mohammed Atta? I've heard the testimony here, but I don't know.
Well, the question,
and by the way, look at Weldon's reaction in the background. Watch this.
Atta. I've heard the testimony here, but I don't know.
well,
I mean, God's sakes, it's right there in Able Danger Zone. Like I said, in the charts, which Weldon provided to the Senate Judiciary Committee, and also provided when he gave months before this on the House floor.
the question was, since you're the only representative of DOD here, the committee would like you to find out the answers to those questions.
Very good.
If we had the secretary here, we would ask him. If we had somebody with knowledge of Able Danger, like General Shoemaker,
Yep.
who was very intimately involved in it, he's not too far away. He's the chief of staff. He was confirmed by the Senate the last time he was up. If we had somebody who knew more about the matter, we'd ask him. And I understand that you were sent over in a very limited capacity with perhaps a calculation that you didn't.
There's a reason why they sent this guy, because they didn't brief him about the Able Danger program, because they didn't want him to know too much about the program. So this way he would give vague answers like this. That's exactly why. And nobody else from the Department of Defense, nor anybody from, no, I'll just leave it at the Department of Defense. Nobody from the Department of Defense basically came and gave additional testimony. In fact, this is the only, I think, the only committee hearing regarding Able Danger. And this is 2005. You weren't hearing anything of it after that. Well, there's good reason why you won't. It's because the program basically worked as it was outlined by Shoemaker and Shelton.
Have this information.
That's why.
But those are the questions which the committee would like to have answered.
Yes, sir.
And if you would undertake the task of finding out the answers, or having your superiors find out the answers, the committee would appreciate it.
Yes, sir. Thank you.
Senator Sessions.
Mr. Dugan, so
This is Jeff Sessions.
Mr. Dugan, to get this ancestry of how we get into these walls that make life in government more difficult, there were church hearings and other abuse hearings that resulted in President Reagan, President Ford, and then President Reagan issuing directives to constrain the activities of the Department of Defense in things that could be considered domestic investigations or domestic law enforcement. Is that correct?
Yes, sir, that is correct. There was also an intervening order from, executive order from President Carter.
And as a result of that, DOD regulation 12333 was issued.
I believe you are referring to Executive Order 12333.
All
That
right.
was issued by President Reagan.
And you referred in your remarks here to a DOD regulation that governed the issue. And is that the regulation from which Major Kleinsmith referred when he talked about AR 381-10?
Yes, sir, I believe.
So the Army implemented that DOD regulation, and that became for the officers and men and women in the Army their binding authority.
Yes, sir, that's correct.
Right. Now, let me follow up on that, because the Pentagon ordered 5 key people in the Able Danger program not to testify at this Senate Judiciary Committee. And Spector would later say that it seemed to me that this was an obstruction of the committee's investigation into the Able Danger program. Now, he said that, and this and he said that, I believe, in after this, not during the committee hearing, but it was off the record. And he basically said that he thought that the Pentagon was actually covering up the fact that the committee was investigating the Pentagon's top brass regarding their insistence in not having people participate in the investigation by the Senate Judiciary Committee. Makes you wonder why. Why? What are they hiding?
All the other services have a similar regulation, as well as the defense intelligence agencies.
And is your understanding that that regulation really was not founded on the Posse Comitatus Act, but some other principle or concern to the executive and legislative branches that led to that?
Yes, sir, that's correct.
What are there any statutory provisions that underlay this executive order and the AR 38110?
The provisions in President Reagan's executive order grow out of the abuses committed by DOD and non-DOD intelligence organizations during the 60s and 70s, as I explained.
Yeah, the Central
and
Intelligence.
Investigated by Senator Ervin, Senator Church, the Church Committee, Representative Pike, as well as the Rock.
Well, I guess
So it's a fear that you have the military collecting intelligence on, let me use the term U.S. citizens, but U.S. persons within this country.
I think that's a big issue. I think it's an important issue. I don't dispute that, and I'm not for eroding that principle in any significant way. But the chairman is, I guess, I think we need to ascertain whether or not there was any statutory requirement that resulted in 381-10 that impacted this particular matter, or was that the result purely of an executive order which could be changed by the chief executive?
I believe it's the result of the executive order. I do not believe it's a Posse Comitatus statute issue.
And you're not aware of any statutory requament that
I would agree with
requires
Dugan
this?
there.
No.
Now, with regard to, see if I can follow up on the chairman's question about sharing this information. There was this 90-day rule that the major and others, I guess, felt they were confronted with. What do you have an explanation of why they couldn't just call Mr. Bald at the FBI and say, we can't hold these documents anymore, we turn them over to you? What would be the difficulty in doing that?
We're a lot smarter now than we were in 1999 and 2000, and we think we could do that. Provide that information to the FBI and say, you need to review this with your authorities in mind to determine whether it's lawful for you to keep. Now, we are faced with that same situation when law enforcement information is given to us for us to look at. And we look at that information in the light of the executive order and the DOD directive and say, is it proper for us to keep this information? Is this of intelligence value to us? And make our decision and determination in accordance with the DOD.
Now, that's funny because 1 year after this committee hearing in September of 2006, the Inspector General of the Department of Defense would conclude in its report that the Able Danger Program did not positively identify Muhammad Atta in the Able Danger Program. So basically, if that was the case, then, I mean, either they're lying, which you know they are. Why is this an argument regarding about U.S. persons that they couldn't use? They couldn't keep this information past the 90-day period if Muhammad Atta was considered a U.S. person. Well, if Muhammad Atta was not identified as a ringleader, what is this argument for? And what is it about? This whole legalese about Muhammad Atta being technically a U.S. person doesn't matter.
The directive or the Army regulation.
Well, so those decisions were made, and I guess we'll follow up, and the chairman has asked, what about this ultimate destruction of the documents? Was that called for under the regulation, or was that necessary?
The 90-day rule is what is referred to as a collectability determination. I have this information. I don't know if I have a reasonable belief that relating to U.S. person information, relating to U.S. persons. And they have this 90-day period within which to make a determination. If the determination after day 10 is this does not relate to one of the 13 categories that I've just described, then the 90-day clock stops. But they have a full 90 days to make that determination. Once that 90-day period goes by and they have not made the information, then it's not properly collected.
It's deemed not to be properly collected, and under criminal law, and the police officer improperly collects something, he does not have to destroy the evidence unless it, but he can't utilize it.
We destroy it.
So you destroy it. So if you delay and haven't made a determination in 90 days, it's to be destroyed. Well, could it not be shared? It has to be shared. What if it's improperly gathered, so it can't be maintained? Can it then be shared?
We think the information can be shared, for instance, with the FBI, as I indicated earlier, for them to review it with their authorities and to make a similar decision or determination whether for their agency they can. Now, why wasn't it done in this case? I can't tell you. Information sharing obviously has increased in significance and importance since the 2001 attack.
I would say so.
We are doing a better job of sharing information, both from law enforcement to intelligence and
Right, 'cause
intelligence
there's no walls
to law
anymore.
enforcement. I'm sure there are plenty of areas necessary and open for improvement. But in 1999, 2000, I guess I wish to convey to the committee that U.S. person information is something that we are skittish about in the Defense Department. We follow the rules strictly on it, and we want to do the right thing and follow the Attorney General guidelines.
Well, thank you, Mr. Chairman. I've had the honor to serve with Congressman Weldon on the Armed Services Committee, he in the House and I in the Senate, and there's no stronger proponent of America's defense, no stronger supporter of the United States Army and the Defense Department and a healthy, strong America. Congressman, thank you for your leadership and for your information you've provided us.
Thank you, Senator Sessions. Mr. Dugan, Muhammad Atta was not a U.S. person, was he?
Great. There it is. And this is the boom right here. This is it.
Based on what I've read in the press since September 11th, 2001, I don't believe he was. He wasn't a permanent resident alien. He wasn't
There
a
it
US
is.
citizen. He wasn't in the other categories. He wasn't in the country lawfully. For instance,
There it
a
is.
student visa or a tourist visa, that is not the same thing as a permanent resident alien.
And there it is. And right there, that means the data that was compiled by the Able Danger team should not have been destroyed. It should have been shared with the FBI, and they would have monitored Muhammad Atta and members of the Hamburg cell in the East Coast, Florida, New Jersey, New York, wherever they went. They went to Oklahoma. They went to Virginia. I mean, they would have been covered. However, there was a foreign intelligence ring. It was the Israeli intelligence ring that were monitoring members of the Hamburg cell. But we don't know what they uncovered because we deported all of them. And for more information on that, go to Robbie Martin's podcast where he covers the Florida cell and the intelligence agencies regarding Israel. And also look into the Gerald Shea memo, which was from the attorney out of California, I think California, that investigated the Israeli art student ring and the moving front companies that were following these al-Qaeda operatives in 1998-99.
So
Mr. Dugan, you're the Acting Assistant Secretary of Defense for Intelligence Oversight. Can't you give us a more definitive answer to a very direct and fundamental and simple question
Weldon
like,
knows.
was Muhammad Atta a U.S. person?
no, he was not.
And there it is. There it is. The data should not have been destroyed.
Well, maybe we ought to continue since we got a direct answer. Mr. Dugan, I know you were sent here by your superiors to do the best you could. I think the Department of Defense owes the American people an explanation as
Sure
to
do.
what went on here.
Mm-hmm.
There are very credible questions which have been raised. And these credible questions have been raised by Congressman Weldon, whose reputation is impeccable as to credibility and thoroughness. And these questions have also been raised by 5 witnesses, all of whom have been prohibited from testifying. And we are not dealing with here on a matter of minor consequence. We're dealing with the intelligence gathering data of the Department of Defense and prima facie reasons to believe that there was credible evidence as to Mohammed Atta, the ringleader, and an al-Qaeda cell, and that had that information been shared and the FBI was trying to get it, 9/11 might have been prevented.
Sure.
And the other senators have expressed the same point of view. Senator Biden finds it inexplicable, can't figure out why the Department of Defense is stonewalling this, and I can't either. I hope you'll go back and talk to the Secretary and tell him that the American people are entitled to some answers,
Mm-hmm.
and this committee on its oversight function, because if there is a problem with posse comitatus, it's our duty to try to correct it. I want to thank the staff especially for pursuing this investigation and this hearing preparation has been one of the most difficult that I've seen, and I'm in my 25th year and no stranger to investigations. Spent a lot of time investigating the mafia, organized crime, and racketeers of all sorts, and never faced a more fundamental question than fighting terrorism, which is the #1 problem we have here today. And we need answers. I want to thank Ivy Johnson and Adam Turner and Adam Caudle and John Noor and Kathy Mickelko and Josh Lederette, and especially Carolyn Short, General Counsel, and Evan Kelly for the work they've done here. And we're going to suspend the hearing on this subject at this point in the hopes that we'll get some better answers.
Unfortunately, there was no follow-up hearing after this one, and that's the problem, is that the Department of Defense were not forthcoming about participating in future hearings regarding the Able Danger Program. It makes you wonder why. Well, in 2006, the Inspector General of the Department of Defense actually issued a report suggesting there were 4 points that were pointed out by the Department of Defense final report, and they were the following: is that they did not publicly identify Mohammed Atta in the Able Danger Program, and that was 1. 2, that the Able Danger members were not prohibited from sharing intelligence information with law enforcement authorities or to other domestic agencies that have acted on the information because Able Danger provided no actionable intelligence. And 3, the destruction of Able Danger documentation at the Land Information Warfare's Activities Division was appropriate and compiled with the applicable Department of Defense regulations. And finally, the program was not terminated prematurely, and Shaffer and Kleinsmith and Mark Zaid all testified that it was, and the report concluded after it, well, the program concluded after it achieved its objective and its work products were used in follow-on intelligence efforts at the U.S. Special Operations Command, SOCOM. So all of this turned out to be false, that there was a cover-up by the Department of Defense, that there was a slander regarding a decorated officer in Anthony Shaffer that was unjustified, including public smearing him in the national media. That the Inspector General's report of the Department of Defense basically lied. Hate to use the word, but they lied basically, because there was actionable intelligence in the program. And this is outlined in the Orion scientific charts. They can't cover up that fact. Yes, they destroyed the tactical data, but the charts survived. They're calling Kleinsmith, Shaffer, Presser, all these people, they're calling liars. Their own employees, to save face, because this information should have been shared and could have prevented 9/11, and probably, would have shed light on who actually ordered the information destroyed and wanted it destroyed, and for what reason. Well, we didn't get answers for that with Dugan. And because there was no follow-up hearings regarding this important program, we may never get that information. But if we could bring light to this incident, if we could bring it back into the fold of the national media, well, then, hey, maybe we can get some answers. But, if we stop talking about these dumb, ridiculous fringe theories of no planes and no hijackers and Judy Wood space beams, and the truth movement gets its head on right, well, then maybe we can hold some people accountable. So that's the end of this video. I'll see you in the next video. Guys, have a good night.